The
purpose of today's meeting is to listen to the submissions from individuals and deputations on the Copyright Amendment Bill 2014. I welcome you all for attending the meeting. I now ask you to put your earpiece on and choose a channel. Channel 0 is floor, 1 Cantonese, 2 English, and 3 Mandarin. Let me remind you that apart from government officials and legislators, those who attend are not protected under Legislative Powers and Privileges Ordinance in regard to what you say and write. And let me draw your attention to the fact that for deputations and individuals attending and members of the public in the public gallery, you will find a notice. You will find the notice attached to the letter sent to you, tabled in front of you for deputations and individuals, and in relation to those in the public gallery, you may ask for a copy from a security staff. There are 171 deputations and individuals attending this meeting. There are 4 sessions, and the second session will start from 11:10. You will have 2.5 minutes to speak for each representative or individual. You only have to go through the salient points of your submission. There is no need to repeat everything. Our usual practice is that the submissions you have given us are uploaded onto the LegCo website. If you don't have a submission, or if you want to supplement, you're most welcome to give them to us after the meeting. And when you speak, please do not use cocktail language. Because it will be difficult for interpreters. First, Mr. Sam Ho, you have 2.5 minutes. Good morning, everyone. I thank you for the opportunity to speak on behalf of the International Federation Against Copyright Theft Greater China Limited. I am not going to read out everything in my submission because of the time constraint. I'll only go through the salient points of our company. Electronic distribution rights. Well, since it's covered by by the International Convention, there are over 90 countries and jurisdictions that have legislated for it. And so far, there is no complaint that this has undermined a freedom of speech. Second point, safe harbor. We basically support the proposal of a safe harbor. Now, cloud industry relies on collective operation of major data center. So far in Hong Kong, there is no safe harbor provisions for internet service providers. This obstructs foreign companies when in their decision to invest in Hong Kong. Instead, they go to neighboring areas like Taiwan and Singapore to build up their data center. Hong Kong has been marginalized. This has stifled the development of our cloud industry. And when it comes to permitted acts, it's been increased from 4 to 6. We find it regrettable. We think it's overkill. Since the beginning of the millennium, when the government consulted the public about IP right protection in the digital environment, it's been nearly 10 years. Time has been wasted. We seriously lag behind neighboring countries and areas. This has a negative impact on our environment. There may be inadequacies in the bill, but we support the endorsement of the bill because we don't want to lose any more time. Next, Mr. Yang Ching-hin. I strongly support the action of the police in dispersing the crowd who occupy Central. I completely identify their work. I salute the police. When it comes to the unpeaceful act of the protesters, some of the police officers have expressed their views. They have changed the lyrics of a song. Well, let me first leave aside Tommy Cheung. Well, according to the official website of the IPD, they said that if the work is not under an exemption, but if they are just to express one's feelings or talent, well, in relation to the 2014 bill, unauthorized distribution that affects the rights of the copyright owners that should be such acts should be penalized. It draws a criminal liability. If the 2014 bill is amended this way, then our police force may be subject to penalty because of the secondary creation. It is not good for Hong Kong. We support UGC option because it is nothing to do with infringement. Including UGC does not affect your ability to curb infringement activities. Some traders resist such a proposal. It is unreasonable. Next, Mr. Ho Sham. Well, you said last year that some people have been misled, and back in 2012, you said that, well, if you have the ability, create it yourself. Never mind. What you see now, actually, is that, well, Mr. Tommy Cheung sang a song that belongs to a copyrighted work. The song "You Raise Me Up" is copyrighted work. When the song was uploaded onto YouTube, it should not be exempted because it's not parody, it's not satire, it's not a caricature, it's not pastiche, and it's not a comment on current affairs. So it doesn't matter that some people have been misled. This bill suppresses room for secondary creation. I am one of those secondary creators. But if you want me to change these copyrighted works to make sure that they belong to the parody, satire, caricature, or pastiche categories, it's impossible. Say, for example, if I change the lyrics of a song from Mandarin to Cantonese to give it a different new meaning that is related to current affairs, but it's not satire or caricature, maybe I will be caught. I really do not understand why it cannot be exempted. In the first session, and a gentleman just now said, well, mentioned about UGC. You should consider this option, UGC. And back in 2011, and in the recent consultation, this idea has been floated, but is been ignored every single time. Every time some people will come out to say that accept it for now. Well, we're talking about my rights too, and my freedom to engage in secondary creation, and my right to freedom of speech. It should be protected as well. So I urge members not to endorse this bill. Thank you.
Ms. Ling. Thank you. Glossary. First of all, on behalf of our organization, I would like to express our regret regarding the notice for this public hearing. Our organization has not received even the agenda for this meeting. We've not even a phone call or an email message. I see many empty seats here in this chamber. I don't know whether or not there are others who are in the same situation. Fortunately, I was able to find my name on the LegCo website. I don't know whether this was done deliberately. Coming back to my submission, why do we need copyright? We do not just need copyright to help us make a profit, but rather to encourage creativity so that our society can develop. I'm sure those who are in the copyright industry agree with that. The Bureau says that there is already an operation model, but the point is that can this model really achieve the original intention, whether or not it can help the development of creativity. If we believe that second creation is a normal creation, then obviously that is not the case. So is there any justice there? And secondly, I'd like to point out that, as the other gentleman said, changing the lyrics, the lyrics of a song will not be subject to exemption, except that there will be exemptions on certain political issues or topics. Furthermore, the government is adding in the communication model. So obviously the bill will not really achieve a satisfactory result. Furthermore, we need more regulation of the copyright charging companies. And also, I'd like to ask who are the OSPs. There are people who have Facebooks or user admin. Would they be considered OSPs? I really hope the government can answer that question, because they haven't yet given us an answer in the course of 3 years. I'd like to ask the all deputations and members of the public can freely, apply to attend the hearing, and when we receive your application, we will serve your notice. Anyone interested in attending the public hearing, or any member of the public, should also pay attention to the notice to visit our website. Next, we have Mr. Sin Long Ching. Thank you. I represent the Comic Society of 8 secondary schools. We are a charitable organization. We aim to promote comics. I think we can make reference of what the government the paper submitted to the government to the Comics Industry panel. So we want to express our respect of the original, author of copyright works. Although the administration had reiterated many times that HEUNG may be incorporated into Section 39, but still we need to. They only consider on a case-by-case merit, and they've not clarify whether or not it is against the law. The administration also say that if you seriously interpret someone else's work for performance or cost remix would not be considered. So in other words, the government has not considered that, and we really would like to register our regret. And we'd like to reiterate our position. First of all, the bill should protect as a purpose, and the bill should, and then doujinshi should not be treated as commercial creation. And I think the Bureau should also build a platform communication with the comics industry and others. We urge every councillor and the Bureau to really respect that doujinshi is, creative works which goes for the truth and beauty. So please listen to the views of different deputations so that this culture will not be stifled and that the comics industry and the digital industry will not be adversely affected. Finally, we have attached an appendix to our submission. These are the doujinshi options proposed by other deputations. Inevitably, it may inevitably, doujinshi creation may generate a slight profit. But next, Mr. Wang Xiu-chi. Thank you, Chairman. Anyone involved in creative works are care a lot about the exemption, and I would like to refer to 39(a), satire, caricature, pastiche, and so on. I don't find a clear definition there. Other than the 4 terms, I have not found any definitions for those 4 terms. And on page 1 of the legislative brief, I find a note explaining what is parody. And the parody is copied from the simplified Oxford Dictionary. It's the abridged version of the Oxford Dictionary. I totally cannot accept it because this is absurd. When I see this, I don't want to even read it any further. For a secondary student to quote something like that would be punished, would be criticized. So can legislators be more professional and come up with a better standard? I don't think this paper was drafted with any seriousness. And the concept of creation has now become more complicated. There are all kinds of theoretical explorations on the subject. We can envisage that there are work circulating on the internet, for which you may not be easy for you to prosecute. There's an anti-forum exhibition last year. I don't know whether or not anyone has seen it, but even if you've seen it, you would not be. So regarding the definition of parody, I totally do not believe that the exemption will work, especially under the current economic political environment. I think that this will be the supplementary provision for Article 23 on the internet. So the public security ordinance was aimed at tackling the triad society, but look at what the government is now doing. The basic law guarantees our freedom to rally and so on and so forth. And now we have the public order ordinance. The basic law says that we have freedom of expression, and I don't understand what's going to happen in future. The basic law is good. It's like the People's Daily. You could read it, backwards. Ms. Lee Chi-kun. I am also someone involved in creative works. If secondary creation could be incorporated as creative works, then why can't our law protect our right to create works as practitioner in the creative industry? If we our right to create works cannot be protected, how can we continue with the creative works that we do? Mr. Ricky Chow Kwok K is next. Ricky Choi Kwok K, I beg your pardon, Chairman. Regarding the Copyright Amendment Bill, I think we've been we already have a very, very rich discussion so far. If we're really going to enact this bill into law, then I think we should consider the following points. First of all, Creative Commons, and secondly, UGC, namely user-generated content. And this is actually in the Canadian Copyright Act. And thirdly, the fair use principle as adopted in the US. The Copyright Amendment Bill in Hong Kong if we want to enact a bill in order to get us in line with international trend, that is understandable. But if we want to protect copyright while at the same time stifling creativity, then it would not be good for the whole society. It's really an irony. And therefore, I would like to suggest that LegCo should seriously consider this, that is, adding Creative Commons, UGC, and fair use provisions into the bill. For me, the parody proposal, I think we've heard a lot of objection to that proposal, and I don't have anything further to add. I hope members will seriously consider Creative Commons, fair use, and UGC. Next, thank you, Mr. Choi. Next, Mr. Kwok Chi Long, Andrew Colvin. Mr.
Making an oral submission on behalf of the Entertainment Software Association. ESA members represent some of the world's leading entertainment software publishers whose releases account for the majority of games, consoles, and software products sold around the world. I want to make just 3 points. The first concerns the communication to the public right. We urge the Bills Committee to consider adding language to Clause 13 of the bill, or otherwise to clarify through legislative history that having the communications right to the public is not intended to alter or override established practices in the marketplace for the clearance of rights, such as triggering an obligation to pay additional compensation for rights that have already been cleared. The ESA has observed, for example, that in some jurisdictions where the right of communication has been implemented, public performance collection societies have sought to claim royalties for the downloading of works such as music used in games, despite the party making use of such works, the games manufacturers, having already paid and cleared the reproduction rights for the work. Such a clarification is designed to avoid scenarios in which users of works are in effect being asked to pay twice for the right to use the work. My other 2 points concern safe harbours for online service providers. ESA members support safe harbours that provide appropriate incentives for online service providers to cooperate with copyright owners in combating online privacy. On the whole, we believe that the safe harbour framework reflected in Clause 50 of the bill is both reasonable and workable. However, based on our experiences working with safe harbour systems in other countries, we offer the following suggested revisions. The first issue is having requirements for online service providers to maintain a repeat infringer program. To ensure the notice and takedown requirement has meaningful impact on piracy, the ESA asks you to consider adding as a condition for safe harbours eligibility a requirement.
Thank you, Agent. Thank you, Angel.
Next, Mr. Chen Ka-chun. Thank you, Chairman. Since 2011, I've already made my submissions regarding the bills, and I shan't repeat the points I've already made before. There are something which the government doesn't understand over the last 3 years, that is the netizens don't want to be arrested and sued. A netizen doesn't know too much about the law. Very often they can only make a literal understanding of the law. But very often the legal meaning is different from our understanding of the law. For example, what is the law? What is minimal economic damages? The government does not answer the question. Is economic damage means $1 or 10 cents? So using vague terminologies like that will make it very difficult for the public to understand. The government always asks us to consider whether or not what we've done infringes the right of the copyright owners, and then you know whether or not you've broken the law. And the court will have a series of factors to consider. And I think in other words, we would need to, find out about whether there are any case laws to help us understand that. So if somebody do some creative works and that involve the police, we have to take the risk of being sued. If you were sued in court or prosecuted, it would take at least 2 years. And the person who is being prosecuted, if the person was a student, he would be subject to a lot of fear and anxiety. So there is the existence of the so-called white terror. When you ask netizens to consult legal advice before they transmit anything, but even if they consult a lawyer, how many case laws are there for them to look at? And I don't think you should ask people to deliberately break the law so that you can create case laws for people to make reference to. The government so far doesn't understand what are the concerns of the netizens. They think that if you enact a piece of legislation, if you're not, targeting against them, why is there such a strong reaction? I think it's exactly because they don't have any confidence in the government. They fear that there is a white terror. They are worried that they may inadvertently do something and have broken the law, and then they'll be arrested. This is not like you claim that you're not targeting against the netizens. So I think you should provide exemptions for all secondary creation before they will have the confidence. Next, or perhaps I will skip the point about safe harbors. Next, Mr. Wang Xiu. Thank you. Thank you, Chairman. It's the first time that I am here in this chamber to make my submission about the copyright bill. I am against this bill. If one reads the provisions in the bill, I have the impression the public can be easily prosecuted. Regarding exemption, I think the government has used very abstract terms like parody and so on. I don't think we should do it the other way around and use terminologies that are more easily comprehensible. Let us say if you directly sell something, or if what you do directly generate a profit for you, then you'll be prosecuted. Furthermore, the media organization should get full exemption. Of course, if there are advertisements, then the copyright owner would know. If the media organizations, especially those news organizations, they should automatically or directly be given the exemption. Regarding the amendments, if you enforce the law and the law is not so clearly defined, then there wouldn't be any protection for the public. So it would be best for you not to enact this piece of legislation. Otherwise, you will be stifling the freedom of creation or creative works, and for the media, you're stifling news freedom. I am an IT practitioner myself, and we all know that the speed of transmission on the internet is very fast. If a general member of the public were prosecuted for something that he's created for, which is only transmitted for 1 second, then he'll be arrested. And finally, I'm worried about the enforcement issue. In case, just if this bill became the law, then people would use anonymous identity when they disseminate any information or make any recreate anything. When the bill becomes law, does that mean that the government will massively collect data regarding the netizens, or will you require people to use their true, genuine names before they can disseminate information? And I'm really worried about that. So, because this is not helping technological development, you are, you are actually stopping people or deterring people from doing that. Mr. Michael Reagan.
I speak on behalf of PCW Media Group. PCW Media is an integrated media and entertainment group based in Hong Kong and a major employer and investor in this sector. Hong Kong needs a robust intellectual property framework to underpin investment, jobs and growth in the media and entertainment industries. But the copyright ordinance has not kept pace with technological and overseas developments and consequently fails to provide that framework. It needs urgent updating. In 1996, the international community adopted the WIPO Internet Treaties in response to the challenges of the digital age. Those treaties have applied to Hong Kong since 2008. The administration began this updating exercise back in 2006, An amendment bill introduced in 2011 was the result of years of deliberation and extensive consultation, but was allowed to lapse. Meanwhile, technology and methods deployed by commercial pirates have continued to develop and are having devastating impact. Online piracy is rampant. Pirated television channels, movies, drama series and live broadcasts are widely available, streamed for free or near free into homes and mobile devices throughout Hong Kong. High-definition media devices specifically enabled to receive pirated services are readily available in Hong Kong. The Hong Kong public is being exposed to criminal organisations masquerading as legitimate TV. The need for updating was recognised a long time ago. It's been thoroughly considered and through an earlier updating exercise which has stalled. In the meantime, commercial piracy has become ubiquitous, mainstream and perceived as legitimate. Passing the 2014 bill is an urgent priority. Let me briefly touch on some of the important proposals in the 2014 bill. The communication right, a technology-neutral right of communication is essential for preserving copyright in the digital age. It will help to close significant loopholes in the current ordinance. It is in the Internet treaties and has been adopted by a long list of jurisdictions and was in the 2011 bill. There's simply no justification for delaying the introduction of this right. Criminalisation of unauthorised communication was also in the 2011 bill. The 2014 bill further clarifies the threshold for criminality. But let's be under no illusion, this will not stop overseas criminal organisations streaming pirated content into Hong Kong. More needs to be done on this front. The safe harbour provisions were also in the 2011 bill. I won't go into that. I just need to say that the committee should not be sidetracked and the priority must be to bring the Hong Kong Copyright Ordinance into the digital age and prevent online piracy from sapping investment and destroying jobs in Hong Kong. Thank you.
Okay, thank you. 下一位係麥天豪先生。
係，各位好。
Next, Mr. McTinhall. Well, I would like to talk about the government's attitude towards IP in the past. This is a poster against Tong, that's in 2001, and CY Leung at that time asked the Department of Justice to send a warning letter to the creator of this. IP was used as a tool to clamp down on freedom of speech. Now CY Leung is the CE, and Lau Xiu-kai, who is in his central political unit, also uses IP as a tool to combat freedom of speech. Now, even the police would alter photos. This is one of the photos they altered. This is against football bookmaking. So for this type of photo altering, is it also exempted? Is this a comment on current affair? It is not commenting on a current affair because this thing has not happened yet. And also for Mr. David Wong, he explained about the copyright bill. He says that this is to encourage creativity and also wants to strike a balance among different parties. But this is not a true balance because the copyright regime should encourage both original creation and secondary creation. Now, it's like altering other people's photos, pictures, videos, etc. If copyright is just used to protect the original creator, and those engaged in secondary creations would have to go to the courts, I don't think a balance has been struck. Due to the time constraint, I can only say a few more things. That is, I hope that more public hearings will be held because the copyright amendment bill is very meaty and we cannot express all our views within 3 minutes. And a lot of people are concerned about this topic. Next, Mr. McCona. My name is McCona, and I speak on behalf of Sky's Comic. I'm one of the administrators. Our organization objects strongly to the Copyright Amendment Bill. Sky's Comic is a platform for creation and exchange. And netizens can take part in our activities, and they are all engaged in secondary creations. They do comics, they rewrite song lyrics, etc. And there are many forums like ours. Sky's Comic and similar forums are small-scale OSPs in the community. And we are all subject to the code of practice. There is now this proposal of safe harbor arrangements. The government officials insist on the notice and takedown mechanism. This complaint system would be very easily abused by the copyright owners. And I think we small forums are being targeted. So even before going to the court, we are asked to take down the relevant content, so we are presumed guilty. The government and the business sector are colluding, and general netizens will be the victims. Copyright infringement, or is the definition of copyright infringement is expanded limitlessly, and this far exceeds what the government officials claim, because they only want to clamp down on large-scale piracy. We are just rewriting 1 or 2 song lyrics, and we will be caught by the net. The government officials refuse to exempt non-profit making and non-commercial secondary creations. Your time is up. We have 4 government officials to take part in a discussion at this meeting. We have Mr. David Wong, Deputy Secretary for Commerce and Economic Development, Assistant Secretary for Commerce and Economic Development, Ms. Fabia Tam, and from Intellectual Property Department, we have Ms. Xiao Chong and Ms. Jasmine Kan. Mr. Wong, would you like to respond to the deputations? I would like to thank the Bills Committee for organizing a public hearing today, so that once again we can listen to the views of the stakeholders on our bill. In the past year, we have made a lot of effort. We came into contact with numerous stakeholders, trying to find a way for improving the copyright ordinance so that it can be kept abreast with the times. On one hand, we want to protect the legitimate rights of copyright owners, and on the other hand, we want to ensure that people can enjoy freedom of speech and creation. Just now, you mentioned platforms, and these platforms are integrated platforms. Users are allowed to upload contents onto these platforms. So we want to find out more about the responsibility of such platforms. That's why we are proposing this safe harbor arrangement. Now, they do not have to bear unreasonable responsibility, and at the same time, copyright owners can have a fast track so that infringing copies can be taken down. And if these are not for infringing copies, the platforms would allow them to have a place to be displayed. So we always want to strike a balance. Just now, we had new comments from users. For example, for the management, would they be regarded as OSPs? Well, we will continue our dialogue with the stakeholders. And also some other users mentioned whether the freedom to secondary creation can be protected. For the copyright regime, the most important thing is that if a creator has won a fruit, then we hope that he can be protected by the legal system, and his creation can also be protected. This is a property right that has to be protected. So that's why we have the copyright regime. Now, of course, for creation, you may have new concepts and you may transform things. So that's why in the copyright ordinance, we already have some arrangements in place. That is, under certain circumstances, you may use a certain work for secondary creations, but there are a lot of conflicts among different stakeholders. And in different jurisdictions, they have different laws. So through this amendment exercise, we hope that we can take care of every parties. This is the spirit behind the amendment exercise. And we are all ears. We want to continue to listen to your views, and we hope that Hong Kong can catch up with the digital environment. Members, any questions? Mr. Charles Mock, Chairman. Just now, Ms. Ling asked some questions, and I want to follow up. She asked the definition of OSP. Well, maybe I missed it, but Mr. Wong, would you like to explain more about this? That is for a netizen, if he has his own blog, what would the situation be like? Would he be regarded as an OSP? And if he takes part in, and if he abides by the code of practice, would he enjoy the safe harbor arrangement? Mr. Wong? Thank you, Mr. Mock. I'll try my best to explain to you. As far as I understand, now there are many blogs, and there is an OSP putting such blogs on a site, and people can express their views through such blogs. And also, other netizens can read these blogs and express their views as well. Now, if you say something or you upload certain infringing photos, then there may be problems. There is such a possibility. So the one providing the platform, if he receives an infringement notice from the copyright owner, then the service provider should abide by the safe harbor provision and take down the relevant content. When he does so, he has to notify the user or the subscriber that uploads the content. He should say that, well, somebody says that you are infringing his rights and I'm taking it down. If the subscriber thinks that he's not infringing the right, then he can send out a counter notice to the OSP saying that it objects to such an allegation. And the OSP should put the contents back. So this is the safe harbor provision. We want to ensure that the OSP will not have to bear unreasonable responsibility, and there is room for the subscriber to maneuver. Well, netizens may form their own forum, so what will happen? And what does Ms. Ling think? Has Mr. Wong answered her question, Ms. Ling? I don't think he has answered my question. And if you want to be an OSP, first of all, your telephone number, your address, your names have to be made public. Then you can enjoy an exemption. I think netizens cannot do this. Maybe I'll try to supplement. Under the existing copyright ordinance, there are two provisions that are relevant. Maybe you can look at them. Section 65 is about service provider. That's a definition of service provider. In simple terms, that is, you should make use of certain electronic means or the network or both to provide connection services or other online services. For example, the Google search engine. That is for the OSP. Now, there are normally 4 types of services that they will provide. When we look at other countries, these are also the major services they provide. First, storage or hosting. So you provide some space or room for discussion or search or information location service. These are 2. And also routing. So for the definition of the OSP, you can see it in section 65. And section 88A, you can see another definition. That is when a person provides a web page online for discussions. Of course, that person is not PCCW. He's not providing routing service. So we have to understand that there are many layers of service providers on the internet. So as the host of a website, do you fall into the category of OSP? And if anything happens on that platform or in a website, and if infringing copies are involved, then whom would the complainants talk to? Now, first of all, the service provider, PCCW. And PCCW would say that, well, this platform is now operated by a certain person. So in the course of all this, if you just provide some network operating facilities or a platform and you don't take part in deciding what the content is, and you know that there is a suspected case of copyright infringement, then you should notify the subscriber that uploads the content, and then you can take down the content, or you give the uploader an opportunity to defend himself. So most important thing is that whether the OSP have a safe harbor, and we will have to look behind the scene. What role are you playing? Are you complying with the relevant rules? That is, have you taken reasonable steps to do things? There are different scenarios, and we have to look at these scenarios on a case-by-case basis. So if you are a host of a website, does it mean that you are an OSP? So PCW will provide you with bandwidth, and then there are other factors that we have to look into before the decision is made and before the safe harbor arrangements can be applied. If there are no other questions, then we would like to thank the deputations and representatives for attending our meeting. Our session ends here. As for the next session, it will begin at 2.